we are talking about succession, wills, inheritance. So what is succession? What is inheritance? Why do we need to know about it? क्यों हमें inheritance, succession, wills इनकी जानकारी होनी चाहिए और कैसे होनी चाहिए, क्या करना चाहिए? Basic knowledge I will try to give it to you. So succession और inheritance एक ही है. हम कितने बार ये कभी वर्ड सुनते हैं succession, कभी सुनते हैं inheritance. It's उत्तराधिकार, विरासत. जो इनहेरिटेंस है हमको विरासत में मिलता है, सक्सेशन है जो हम उत्तराधिकारी है, उत्तराधिकार मिलता है. So when does succession and inheritance of a property or estate or movables, immovables take place? It takes place on the death of a person. So succession is the process by which the estate, that is movable and immovable properties, are distributed among the mainly the heirs. Normally it is the heirs or anyone nominated if there is a will. So there is a succession in India. It refers to immovable property and movable property. Immovable property follows the law of the land where property is situated, and movable property jahan deceased person was domiciled at the time of his death. So आप भले ही इंडिया में आपकी डेथ है, लेकिन आपकी प्रॉपर्टी अगर लंदन में है तो लंदन का लॉ अप्लाई होगा, इंडिया का नहीं, भले ही आप इंडिया में रह रहे थे. So that is how the succession is related to movable and immovable property. Now succession depends on testacy and intestacy. There are two forms. Succession means हम उत्तराधिकार हमको विरासत में कैसे मिलता है. There are two ways: testamentary succession and intestacy. So intestacy, intestate succession, where there is it is provisions of Hindu Succession Act will apply here, and intestate succession means जब where there is no will, और पर्सन जब जिनकी डेथ होती है वो बिना विल, बिना कुछ लिखा पढ़ी किए अपना सब कुछ छोड़ के चले जाते हैं. So that time Hindu Succession Act will apply, and अगर उसमें से दोनों, अगर husband wife spouses are Hindus, then Hindu Succession Act will apply. अगर intercaste marriage है, Hindu Muslim की, Hindu Parsi की, Hindu, then the marriage is normally solemnized under Special Marriages Act. इसलिए Indian Succession Act will apply and not Hindu Succession Act.
Okay, thank you सावित्री जी.
Then
अब जैसे कि आपने बताया कि अगर हम विल बनाते हैं तो इंडियन सक्सेशन एक्ट को फॉलो किया जाता है. तो नाउ कैन यू टेक अस थ्रू द प्रोसेस कि विल कैसे बनाते हैं और उसको इफेक्ट और एनफोर्स कैसे किया जाता है, इसके बारे में थोड़ा ब्रीफ बताएं.
Yeah. So what is a will? Will होता क्या है? Will means will falls under the testamentary disposition, where a person writes, or it is a writing. Will is a document, a writing which indicates the intention of the person कि मेरे बाद मेरी immovable property, movable property, my estate किसको जाएगी, कैसे जाएगी. So he writes it down in the format, and that is called a will. Who can make a will now? Any person can make a will, but he has to be of sound mind and who is not a minor. So अगर आप normally insane है, but जिस दिन आप, sometimes you're mentally unstable, but when you're making a will, that day you're stable, or that part of the day you're stable and it can be proved, then you're capable of making a will. Then a married woman also can dispose of her property, whether she takes it before the marriage or after the marriage. By a will, she can give away her share in the property, whether it's ancestral or whether her self-acquired property, or which she is likely to get. So a married woman also can now make a will. So even a deaf or a blind or a dumb person can make a will if they are capable of knowing that what they are doing. Like अगर एक deaf है but he can see and write, dumb hai, he can't speak but he can write, so all, and a blind person capable of writing in his own braille language, so all these people are competent to make a will. So how what is a valid will? A will has to be done, the format need not be as there is a normally a format provided in the Indian Succession Act or a High Court rules and all. But the main thing is it can be in any form, but there has to be signature of the testator and attestation by 2 or more witnesses. So both the witnesses may not the witness A can sign today and the witness B can sign tomorrow. But at both the witnesses has to sign in the presence of testator. I can't make a draw up a will and send it. Okay, जाओ B से sign करवा के ले आओ, A से sign करवा के ले आओ. No, they have to sign in my presence. So that's how a valid will be there. Now, what is the registration of a will? Normally, many times we get मुझे questions आते हैं कि मैं will बना रही हूँ, मैं register करवा लूँ और better होगी और strong होगा, कोई challenge नहीं कर पाएगा. So registration of will and Indian Registration Act, there's no compulsory, no mandatory to register a will. But it helps in establishing genuineness of a will. If there is a registered document, obviously it has a larger standing before the court. कोर्ट में अगर केस गया, किसी ने बिल चैलेंज की, तो अगर वो रजिस्टर्ड है तो नेचुरली इट विल गेन सम वेटेज. नाउ बट अगर रजिस्टर्ड विल है, बट इट कैन ऑल्सो subsequent will can be made and a registered will can be negated. That means if अगर पहली will registered है और subsequent will से मैंने वो change कर दिया है, तो मेरी subsequent will be valid will and not the registered will.
Oh, thank you, Savitri. अब जैसे कि आपने बोला कि I can make a new will in spite of registering an old will. तो इसी तरह अगर suppose मैंने एक will बना दी है and then I change my mind, मुझे अब उस will के हिसाब से नहीं चाहती मैं कि मेरी property बांटी जाए to my heirs, तो उसके लिए हम क्या प्रोसेस फॉलो कर सकते हैं और कैसे अपनी उस विल को बदल सकते हैं या नई विल को कैसे इफेक्ट दिला सकते हैं?
So depends now. अगर तुम चाहती हो कि मैं मेरी पूरी विल, मेरे सारे एसेट्स मुझे डिफरेंटली अब देने हैं, तो यू कैन मेक अ न्यू विल, बट एंड it will supersede the earlier will. So subsequent will be valid and the previous will stand cancelled or revoked. If you want only one aspect of a will, like एक property या एक shares खाली change करना है कि नहीं अब ये मैंने बेच दिया है या मुझे नहीं इसको नहीं A को नहीं B को देना है, then you can execute another document which is called a codicil. So a codicil में खाली आप उतना part ही deal करोगे and you will mention in the codicil कि rest of the remaining will, मेरी original will is valid, only this much part I am changing by a codicil. So the document by which we change the original will is called a codicil.
Okay.
And how can also if you want to change the change entirely the will, you can just tear it off the originals and any copies you have. Another is when can your will be revoked? On marriage, a will stands revoked automatically
without
in law.
Any formal procedure, it stands revoked. ऐसा?
Yes.
Okay. And okay. फिर अब अगर मेरे पास will है तो उसको enforce कौन करेगा? जैसे how मेरे जाने के बाद how can I ensure कि वो will मेरे मर्जी के हिसाब से मेरे assets distribute किए जा रहे हैं?
Okay. So जब हम कुछ विरासत में देते हैं, अंडर अ विल वी आर गिविंग सम प्रॉपर्टी, सम शेयर्स टू समवन, द पर्सन जिसको हम दे रहे हैं ही इज कॉल्ड अ लेगेटी और अ बेनिफिशियरी अंडर द विल. सो जैसे हम लोग ने एक विल बनाई एंड द पर्सन मेकिंग द विल डाइज, देन द whatever the bequest, whatever विरासत में हमने दिया है, वो automatically उसके rights में उसके rights आ जाते हैं. Only thing is there has to be a procedure followed to formally in writing to be transferred to that person's name, to the name of the beneficiary.
Okay.
And who will do it? So normally एक will होता है जिसमें एक executor and trustee has been appointed by the writer of the will. The writer of the will appoints A, B, or one or two people who are known as executors or trustees of the will. Executor means he will be executing the desire, the whatever he has said in the will. All the steps have to be taken by the executor. He is the executor is a legal representative appointed by the testator in his will, or by implication also. Suppose sometimes it's not clear कि ये executor है या क्या है, but if he keeps without saying that he's the executor, if he says this person is going to do this for me, so he stands appointed as a executor. The main duty of the executor is carry out the wishes of the testator, the deceased person, to distribute the assets as per the will. The executor is the person who is responsible for managing and protecting the estate of the deceased person till the entire estate is distributed and transferred to the rightful people.
ओके मैम, थैंक यू. जैसे कि आपने बोला कि एक प्रोसीजर फॉलो करना होता है, इवन फॉर द एग्जीक्यूटर उसको एक प्रोसीजर फॉलो करना होता है टू एनफोर्स द विल, टू डिस्ट्रीब्यूट द एसेट्स. वो प्रोसीजर क्या होता है और कैसे उसके लिए अप्लाई किया जाता है, उसके बारे में बताइए प्लीज.
So the executor can't just say, okay, मैंने ये प्रॉपर्टी, मेरे पास बिल की कॉपी है, मैं इसको दे रहा हूँ, मैं उसको दे रहा हूँ. That will not be accepted. So there is a procedure to get a probate. Probate is a grant certificate which has to be obtained by the executor from a competent court, normally a high court or a district court. What is a probate? Probate is a certificate issued by the high court or the competent court or district court, certifying that the will is a genuine and valid will, and it can be granted only to the executor of the will. And even if there's original will is not found, it can be granted on a copy of the will if the original will is lost or misplaced. Now,
so ma'am, the court will basically vet the document. The court check करेगा कि will genuine है कि नहीं, ऐसा?
Yes, there is a procedure. You have to file a petition for probate. Then there is a testament. There is a separate testamentary department assigned for this work in the courts. And that department, the minute you file an petition, they will ask you 10 procedures to be followed to issue citation to the legal heirs, notice to the legal heirs, and if suppose there are 3 heirs, A, B, and C, under the will the property is given only to A and B. So the notice will go to all A, B, C, and if the C person feels that, oh, even I should have been given, he can challenge the will and file a caveat. The minute he files a caveat, the petition becomes a suit, and the will has to be then fought it out.
Okay. Thank you. Please continue.
So the executor, the minute the will is there, immediately first step, he has to file for the petition for probate, and he has to write to all the heirs that this is the will, I am the executor, I am filing the petition for probate, and please give your consent or whatever. And also he will write to all the companies and banks and institutions saying that sending a copy of the will that I am the executor applying for the probate, and any communication you have to do to me. So he actually administers and manages the estate till the probate is actually received.
Okay.
Because it takes time, at least 6 months or something, to get a probate from the court.
And then he distributes the assets as per the will.
Yes.
After probate is received.
Yes.
Okay. In case, for example, आपने बोला कि an executor has to do all this work. अब अगर विल में आई हैव फेल्ड टू मेंशन एन एग्जीक्यूटर, मैंने कोई एग्जीक्यूटर नहीं अपॉइंट किया है, या फिर मेरा एग्जीक्यूटर मेरे से पहले ही ही पासेस अवे बिफोर मी, तो हम क्या कर सकते हैं? या फिर आई डोंट इवन हैव अ विल, तब फिर मेरे एसेट्स को कौन मैनेज करता है इन माय एब्सेंस?
Okay, so there are two parts to this. If there is a no executor appointed under the will, but by implication you can make out कि ये person को सारे काम करने बोला है, तो that person can be nominated as an executor. Suppose there is no executor at all, but the will is there, then we can file for a letters of administration. Instead of a probate, you have to apply for letters of administration. More or less the procedure is the same as a probate and letters of, the only difference is that there are letters of administration is applied under two circumstances. One, when there is a will but no executor is appointed, and second is when there is no will at all, but movable immovable property काफी है and stakes are high, and the people the authorities are not willing to transfer, so you go to the court and say we want to act as administrator of this property, and please issue letters of administration for this immovable and movable property. So what is letters of administration? It is an order similar to that of a probate, issued by the High Court, competent court, appointing an administrator for managing assets of the deceased and for distribution and all.
Okay.
So administrator and executors have the same duties.
Okay, understood.
Now, who can be appointed as administrator? Those who are interested in the estate. So they can approach the court and say, please appoint us an administrator. And it's on the court to decide amongst who should be the rightful administrator. Or it can be a third party also.
It can be a third party, but it is not necessary that he has an interest in the property. Is that so?
There. Yes. Any officer of the court can be, like an advocate can be appointed, anyone. It's at the discretion of the court.
Okay. So the advocate will also have to apply to the court saying that I want to be an administrator for the property.
No. The court on its own may decide that no, these people are the claimants. There are 2-3 claimants and they are fighting among themselves. So we will appoint some other person, and they may ask in the court anyone interested, or the judges themselves know that this will be the rightful, like senior advocate or some other advocate whom are known to the judges. So they may recommend them to be appointed as an administrator.
Okay, thank you, ma'am. So now, if you could tell us something about a succession certificate and how is it different from letters of administration and the probate? Because this is the most catchy certificate that comes to the mind of people, the most common one.
Yes. So when there are immovable and movable property, then probate and letters of administration under the circumstances I explained. So, and when there is only movable assets like debts, security, shares, promissory notes and all this, then you have to apply for succession certificate. Normally the company shares and banks and all, they will install. If there's no immovable property, then succession certificate has to be applied. Now that also is issued by the testamentary department in the High Court or whichever court. It is issued by the High competent court, establishing rightful successor of the deceased to debts and securities. So only to movable assets.
Okay.
So it doesn't require the appointment of executor or administrator. Anyone can, like suppose I have been asked that my name is a jointly in the I am the nominee of shares, company shares, but the company is saying no, please get a succession certificate, then only will transfer. So the nominee, so you'll have to apply to the court to get a succession certificate.
Okay. And the effects of succession certificate is that जो certificate जिसको मिलता है उसके नाम पे सारे Debts
Yeah,
or security.
it will mention, the succession certificate normally mentions that this is the successor or legal representative being appointed by the High Court for realizing the debts and securities of the deceased.
Okay, ma'am. Thank you.